Testing 1, 2, 3. Good morning, everyone. Just running through some housekeeping. My name's Diana Olson, and I'm with Corney and Lind. And we've got Alistair Macpherson here, who will be presenting. And I'm just wanting to do a check. If you'd be able to go into the chat to say that you can hear me clearly, just a tick or a yes to say that that the technology is working. Fantastic. Thanks, Bernie. Thanks, Sarah. Okay, we've got a few people already online, so maybe we'll make a start. Welcome to today's webinar, and it's on responding to sexting and student sexual abuse. If you experience any audio difficulties during the presentation, please let us know via the chat box on the right-hand side of your screen. You will also have the opportunity to submit written questions. If you'd be able to do this at the end of the presentation, that way Alistair can just run through all the slides, and then we'll save the questions for afterwards. A little bit about Alistair. He is the Managing Director for Corney and Lind Lawyers. He is an Australian legal practitioner, was admitted to the Supreme Court of the ACT in 2001, and has experience in Canberra, New South Wales, and Queensland jurisdictions. Without further ado, there's more on our website about his credentials. But if you have any questions for the presentation, please save it till the end. And without further ado, I'll hand over to Alistair.
Thank you very much, Diana, and it's a pleasure to be with you all today. I'm sorry if my voice sounds a little bit croaky. I'm coming off the back end, hopefully, of what's been going around Queensland at the moment. So I do apologise for that, but hopefully you'll still be able to follow what I say. So today what we're looking at is this area of how a school might want to respond to sexting and student sexual abuse. And I'll look at that in the context of, well, first of all, what are some of the case studies that have been around? Some of the case studies coming back from 2016, 2017. There's far more recent case studies, but when I initially wrote this paper, that was when the case studies are that I'm looking at, but it's not really all that changed since then in any event. I'll then move on to really think about how you can better educate your students around sexting and the implications of sexting for them personally, because it seems to me a key issue is around making students aware that sexting can have some quite serious ramifications for them personally if they are the ones doing the sexting, and can also have very serious ramifications for those who might be the unwanted recipients of sexting. So the purpose of this paper is to provide you with some understanding of those legal ramifications so that you can be able to share that with students as well. So I'll look at it from a criminal perspective. I'll also look at it from a privacy perspective, as well as from a breach of confidence perspective, a defamation perspective, and then I want to shift to look at the duty of care implications for the school in how it responds and deals with sexting. Before then shifting across to, well, what happens if you actually do have instances of sexting, and what are your reporting obligations? And as part of that, I'll also look at the reporting obligations that are being proposed under the new failure to report offence in Queensland, which has only just been distributed as a draft bill at this stage for consultation, but we would expect that would pass. What that might mean within the school context, and then finish off by thinking about, well, how is it that you might want to then respond, taking into account all of those issues. So that just gives you a bit of an understanding of where we're heading. So let's have a look at first some of the case studies, and these are just case studies I pulled off the net. There's probably nothing particularly unusual in these case studies. It can happen, I'd suggest, at any school. So an ABC News article in Queensland commented back in 2016 that the Queensland Sentencing Advisory Council study showed that there were 3,000 and, oh, actually, sorry, that's a further slide. I've changed a little bit too quickly there. First case study I've got actually comes out of the United States, and that's involving a new town in the United States where 5 students were actually charged with sharing nude pictures and videos of their classmates. That followed the high school's investigation about what had occurred. What school administrators learned is that several boys and girls were sexting each other. They were sharing nude photos and videos of themselves and their classmates through applications at the time being Snapchat, FaceTime, iMessage and Kik. So 3 students had actually charged money for sharing these pictures, so there was some commercial gain that these students had obtained as a result, which aggravated the circumstances. Those teens were arrested. 20 others were referred to a juvenile review board for sharing those images, and 2 students were charged with misdemeanor counts of child pornography. So that's something that comes out of the United States, and when I looked at that I thought, well, is that a United States issue? But then as I kept looking, it became very clear that it was also an Australian issue. This is a report from Sergeant Andy Stott, who basically said that he was the crime prevention section down in South Australia. He commented to ABC News that underage students were engaging in the act of sexting, and they didn't actually understand and realise the severity of what they were doing and the fact that what they were doing amounted to a criminal offence. His words were, it's non-stop. We have many, many offences and occurrences happening in our schools on a daily basis. There were changes legislation being drafted at the time by the South Australian government, which was creating a new offence down there of filming and sexting for those under the age of, say, 17. But then he noted that irrespective of that, those minors who were involved in sexting could still face child pornography charges, which is quite a serious matter. He commented that this is really a highly offensive matter. It's a major indictable offence. It's very serious. It's up there with the biggest and best of them as far as crimes go. Now, you'd probably say that particularly in the context of the type of crime that we're talking about and the implications that that crime can have on someone from a personal perspective. He noted that even in cases which did not go to court, police could still seize and destroy any device, so the phones and the like, on which they believed offending images may be saved. Moving then closer to home in Queensland, the Queensland Sentencing Advisory Council did a study on this, and they revealed that 3,035 people have been dealt with between 2006 and 2016 for child pornography offences over that 10-year period. Of that, though, 1,470, so almost half, were aged between the ages of 10 and 16, and their offences mostly related to underage sexting, filming or distributing explicit material of people under 17. So that just demonstrates that a large number of the matters that are actually being put before the courts around this area are actually involving children and minors and what they're doing with each other. Moving on then, some of you may recall the Australia-wide website and ring that was disclosed a couple of years ago now, involving many schools around Australia and highly regarded schools, might I just say. So, we had 70 Australian schools that were being targeted by a ring of teen boys and young men, secretly swapping and exchanging graphic sexual images of female students and other non-consenting women. More than 2,000 images were posted or traded by Australian members since that group began operating in December 2016. Hundreds of individual names then appeared on wanted lists, including the names of sisters and entire high school friendship circles. So what was happening was that students were putting names of other people up on this particular website and saying, see if you can find or get some photos of them to distribute, which was very, very concerning, really. Once a girl's name appeared on the list, other members of the group would then contribute by posting identifying information about the intended victim, such as her full name, her face, her school, home address and phone number, along with directives like, go get her, boys. And I think we'd all appreciate just how shocking that culture was. What was really concerning about this, as I've already mentioned, is that just the sheer number of schools that were being targeted, and schools that when you read through it at the time, it was really a who's who list of very high profile schools as well, and schools that would really regard themselves as ordinarily not having to deal with issues of this type and this nature. And obviously that then has a significant reputational risk for the school involved. So that's what we're talking about. Let's now turn and ask ourselves, well, what does this actually look like as a criminal offence in the first step? And here I'm looking at criminal offences under the Queensland legislation and the Commonwealth legislation. But the reality is that the offences I'm talking about are really mirrored in all of the jurisdictions around Australia. So really there's not a lot of difference between what we have in Queensland and what another jurisdiction might have. Here in Queensland, we've got our criminal code, because our criminal law is essentially codified. It's been like that for over 100 years. And essentially the offences that come under the criminal code relate to child exploitation material and child pornography or child abuse material. So child exploitation material is essentially any material that is likely to cause offence to a reasonable adult, which describes or depicts a person who is a child under the age of 16. So just note that age limitation here under the Queensland Act, where it depicts them in a sexual context, including, for example, engaging in a sexual activity. Alternatively, it depicts them in an offensive or demeaning context, or it shows them being subjected to abuse, cruelty or torture. So it doesn't need to be simply sexual, doesn't need to be pornography. It is quite a bit broader than that. It talks about what is the actual material that's depicting the particular person, and is that material likely to cause offence to a reasonable adult. And then the actual offences that flow from that definition are a few-fold. Firstly, there's probably the higher level offence of actually making child exploitation material. So that's when you might have actually taken the photo, taken the video, or created the image. Then that's subject to a 14-year imprisonment total. There's then the offence of possessing child exploitation material, also 14 years imprisonment, but it would be seen as not quite as serious by a court as the actual making or distribution offences, but still seen as serious. Involving a child in making child exploitation material, again, that would be a more serious aggravating offence because you're actually exploiting the child to create the material. And then there's distributing the child exploitation material, where you're actually then passing it on to someone else, whether it's electronically or hard copy distribution. Now, what's a key factor here, and this came out of a Queensland Court of Appeal decision of Campbell, is that for this offence to occur, it doesn't need to simply be a photograph or a video image, nor does it even need to relate to a real person. It just needs to extend to the content which is likely to cause offence to a reasonable person. So it could be for example, literature content. So if someone writes something which is highly demeaning of a person under the age of 16, highly offensive, or suggests that a person under the age of 16 is engaging in sexual activity, you can still bring in these particular provisions. So the court there said, by parity of reasoning, I presently see no reason why a piece of literature that describes someone being a fictional character who is a child under the age of 16 might not fall within this definition. So that's just interesting to note. Students probably also need to be careful when they're writing stories, for example, and the like, that the content that they're putting into their stories, they need to bear in mind that it still can't breach these types of provisions. Then we've got the child pornography material and child abuse material under the Commonwealth Criminal Code. So here we're switching from the Queensland legislation to the Commonwealth legislation. And this is essentially child pornography material is anything that now depicts a person under the age of 18 years. So it's lifting the age limit by another 2 years, where they're engaged in or appear to be engaged in a sexual pose or sexual activity, depicting for a sexual purpose their sexual organs, etc. In the circumstances where a reasonable person would regard it as being offensive. So you've still got that test about whether it would involve a reasonable person regarding that particular image being offensive. And that's something that a court or a jury would need to decide. And so that would be particularly a relevant factor, I would suggest, when you're talking about the age of between 16 and 18. The jury would need to ask, well, what's the content and would it be regarded as offensive? Child abuse material, again, any person under the age of 18, where they appear to be a victim of torture, cruelty or abuse, where a person would in all the circumstances regard that as, again, being offensive. And so this is where it's picking up that child exploitation material in the Queensland Act. Here in the Commonwealth, it actually separates it, instead of being under the one, separates it into two. And it needs to involve a carriage service, because essentially for it to come within Commonwealth legislation, there has to be some link back to a Commonwealth power to make laws. And so around this area, generally the power will be around the use of a carriage service, which flows out of the Commonwealth Constitution. Historically, that would be things like the mail and the post, but now that's been obviously expanded to internet, mobile phones and the like. And so it's when a carriage service is being used to access, transmit, publish, distribute or promote that particular material. Important to note as well that for these types of criminal offences to be pursued, the Attorney General of the Commonwealth needs to consent where the prosecution is of a person under the age of 18. Then we've got, now switching again back to the Queensland legislation, we've got another offence called stalking, which many of you may have heard about. For an offence of stalking, the age of the victim is immaterial. It doesn't matter how old they are. It more comes down to what is the conduct that is complained about, and does it amount to stalking of that person. And so stalking is defined in the Act as any conduct that's intentionally directed at a person, being the person who stalked, and ordinarily, it would be engaged on more than one occasion, so there'd be multiple, at least two or more occasions to amount to stalking, unless, and it's an important factor, unless the conduct, if it is within one occasion, is protracted in nature. So it's not just one simple contact or conduct, it's really a more protracted conduct. But that may certainly amount to protracted conduct if it's something where particularly sexually offensive material of that person has been distributed to others. You might find that you've got sufficient conduct to say it's protracted on the one occasion. And it then needs to fit within one of those next subcategories, which basically is one or more acts of the following. Either the person contacts the person in any way, so if they communicate by phone or text message or through some form of an app. They leave offensive material where it be found by, given to or brought to the attention of that person. They give offensive material to that person either directly or indirectly. So if they give it to someone else and they say, yeah, you bring it to their attention, that's an indirect giving of the offensive material to them. Or it's an intimidating, harassing or threatening act that would cause them to have fear or would cause detriment to them. And that final one is a key one. So if they distribute sexually offensive material of the particular individual concerned to other people, then that may well cause detriment to the stalked person, in that it may very well cause reputational damage, psychological damage, or the like. So that's really where you start to see this detriment being picked up on. We've then got another offence, which is making a recording of someone in a private setting and then distributing that. Here, the age of the victim, again, is immaterial. It's essentially where a person either observes or visually records another person in circumstances where that person would expect to be afforded privacy. So, for example, they're engaged in a private act in a private place, so showering, toileting, getting changed within a private dressing area, for example. Those are the types of things. If there's some inappropriate videoing going on, then you may find the person who's videoed it has breached this particular section as well of the criminal code. Otherwise, it can also extend to visually recording or observing a person's genitals or anal region, again in circumstances where they should be afforded privacy in relation to that region. And there's a further offence where you actually distribute that recording to someone else. All of those offences carry 2 years imprisonment, but obviously the distribution would be a more aggravated offence than the first two offences. That's not to say, though, that just because the person commits an offence under that final provision doesn't mean they won't have committed offence under one of the earlier provisions. And it's up to the prosecution and the police ultimately to decide which charges are the appropriate charges to bring, and they may decide to bring multiple charges where they consider that it is supported on the evidence. Moving then on to, well, okay, you've got a student, they've committed these types of potential offences. They might say to you, well, I'm young, I'm really not going to be held accountable by the courts. And this is where the concept becomes, at what age does a child or a minor have criminal responsibility and is able to be dealt with by a court? Unless the child has criminal responsibility, they can't actually be dealt with by a court. The court simply cannot deal with it because they'll say that the person doesn't understand that what they were doing was wrong, therefore they don't have criminal responsibility, and the matter simply won't proceed. Going right back in time, that age was 7 years of age. So once the person was younger than 7, they didn't have criminal responsibility. Once they hit 7 years of age, they did have criminal responsibility. All Australian states and territories have changed that now to be setting the age of criminal responsibility to essentially 10 years of age. So up until the age of 10 years, a child does not have any criminal responsibility, can't be charged for an offence. From the age of 10 until 14, there's a presumption against criminal responsibility, but that's rebuttable. The prosecution can still bring a charge against a child, and they would need to prove that the child had capacity. I'll talk about that in a moment. And then once a child hits the age of 14, they have criminal responsibility, and there's no need for the prosecution to prove anything. So any child who's over the age of 14 who says to you, I don't have criminal responsibility, or they won't say that, they might say, well, the courts aren't really going to mind because I'm still pretty young. You can actually say to them, well, no, that's definitely not the case. Once you hit the age of 14, you can be brought before a court. And even between the ages of 10 and 14, you can still be brought before the court. It's just a requirement for the prosecution to prove that you had the capacity to know that your conduct was seriously wrong. And essentially what the prosecution needs to show is that the child had that power to discern between good and evil. That goes right back to the 1800s, hasn't really changed that much. Basically, it's whether the child was able to appreciate that what they were doing was seriously wrong. They don't need to prove that the child knew that what they were doing was criminally wrong, was a breach of the criminal law. They just need to show that what they were doing they knew or should was seriously wrong, and not simply that they were being naughty or mischievous. Certainly, as the child is getting closer to the age of 14 years, that would be far easier for the prosecution to rebut that rebuttable presumption. As they're getting closer to the age of 10 years, it might be more difficult. But that's a matter for the prosecution, ultimately, to prove that matter to the court, and they'll look to lead any evidence that they can to show that. Certainly, if the child has been previously convicted of an offence, that would be a clear evidence that they have criminal responsibility. The other thing that's interesting is where they can demonstrate that a child has actually come from a well-to-do family. They've been properly brought up and they've been generally well behaved. The expectation or the implication that then follows is that they would know what is right and wrong, and that they shouldn't be doing things that are wrong. So that's it from a criminal perspective. What about from a privacy perspective? Can the individual concerned be held responsible for the person's breach of their privacy? Now, this is not a breach of privacy in the context of the Privacy Act. The Privacy Act won't have any implication here, because the Privacy Act only applies to institutions that either opt in or alternatively have a turnover of more than $3 million. So the Privacy Act obviously applies to you as schools, but it doesn't apply to your students who go to the school. So that's the first thing to make a note. So we're not talking here about breach of the privacy principle, the Australian privacy principles. That's not what this is about. This is about talking about, well, is there a common law right that a person can expect to have privacy in their life? And historically, the common law hasn't recognised that. They said, no, look, we don't think there is such a common law right. If you go right back to a 1930s decision, which involved a horse racing track, a neighbour of the horse racing track put up a platform next to it in which they were able to broadcast the horse racing as it went round the track on radio. The horse racing track wasn't too happy about that because it infringed, they said, on their privacy and their commercial interests. They took that all the way to the High Court, and in that case the High Court said, look, whilst it might be desirable to have some limitation upon invasions of privacy, there's been no authority cited to show that that actually exists. Now, it's important to note that this case is in the context of a commercial dispute, not in the context of a personal dispute. So then if you fast forward to an ABC decision and Lena Game Meats in the early 1990s, that involved a possum meat processing facility, and essentially media representatives went in to I don't think they were actually media representatives who went in and did the videoing, but someone went in and did some videoing of what was happening within this processing facility to then broadcast that on the ABC. And Lena Game Meats brought an application to seek to injunct the actual proceedings from being aired on the basis that that was, again, a breach of their privacy. Again, we're talking about a commercial dispute, not a private dispute. But the High Court said, well, it's possible that a common law right to privacy could exist, depending on the circumstances. And the older decision of Victoria Part is not authority that such a right can never exist. It will depend upon the circumstances of the matter. However, there had not been any unjustified invasion of privacy. So then we fast forward to a 2003 decision in the Queensland District Court. And this one's a little more interesting because now we're talking about a breach of privacy within the context of an individual's rights and a personal relationship where privacy was being infringed upon. So instead of commercial rights, all of a sudden now we're switching to whether an individual can complain about their privacy being infringed. This case involved serious allegations of stalking and harassment by the defendant, and it came out of a failed domestic relationship. So the plaintiff and the defendant were in a relationship, they broke up. While they were in their relationship, there'd been some videoing of their sexual relationships. So the defendant had a copy of these videos and he was distributing those videos. Now, the court accepted that there had been many occurrences of stalking by the defendant and that this actually did amount to an invasion of the plaintiff's privacy. The judge at the time, Senior Judge Skane, said, "It is a bold step to take, as it seems to me. It's the first step in this country to hold that there can be a civil action for damages based on the actionable right of an individual person's to privacy. But I see it as a logical and a desirable step. In my view, there is such an actionable right." And then he then thought about, well, what would that right entail? What would someone have to prove if they wanted to demonstrate that their privacy had been breached? And he came up with 4 key elements. First, that the defendant had done something that was a willed act. So the willed act by this defendant was to distribute very private videos. He knew what he was doing when he distributed them. Secondly, that act intruded upon the privacy or seclusion of the plaintiff. So the plaintiff was entitled to privacy and seclusion in relation to these particular videos, and that the act of distributing them was intruding on their privacy or seclusion. And it was being done in a way which would be considered highly offensive to a reasonable person of ordinary sensibilities. In some respects, again, we seem to be picking up on these same principles that we saw earlier around child pornography. Would this be considered highly offensive to a reasonable person? And then thirdly, which causes the plaintiff detriment in the form of mental, psychological or emotional harm or distress, or which prevents or hinders the plaintiff from doing an act which he or she is lawfully entitled to do. And so in that case, damages were awarded to the plaintiff of $178,000. Now, the decision was taken on appeal to the Court of Appeal, but unfortunately it was settled by the parties before it was actually heard. So we didn't get any Court of Appeal authority out of this. It would have been great to have actually had some Court of Appeal authority on it, but at this stage what we had was a district court decision. Moving a little bit more forward into 2008, we have a Victorian Court of Appeal decision which goes the other way around privacy, but that was because, I think, the court was able to find another basis to find for the plaintiff. In that case, Gillett and Prosopes involved again a breakdown of a de facto relationship. Very similar circumstances to Gross and Purvis. Again, during the relationship, the defendant had videotaped he and the plaintiff engaging in sexual intercourse on numerous occasions. The court noted that the existence of a generalised tort of invasion of privacy has not yet been recognised by any superior court of record in Australia. Really, that word superior court of record is saying, well, we don't have authority at the Supreme Court or a Court of Appeal or High Court in this area at this stage. So the Court of Appeal wasn't prepared to find in relation to a breach of privacy. And that was because the court was prepared to find an alternative basis on which to found the claim for the plaintiff, and that was an equitable breach of confidence. So they essentially didn't consider the tort of privacy any further. So what was this breach of confidence? Well, in some respects, the equitable breach of confidence is not a great deal different to the tort of privacy. Essentially, it simply revolves around an individual who's receiving information of a confidential nature, and that information is received in circumstances of confidence. Usually we're talking about trade secrets in equitable breach of confidence. Our company has something that's particularly secretive and confidential. They give it to another company, and the other company manages to get hold of it. They're trying to exploit it for their own commercial gain. And the other company says, hang on a second, we own that, you can't do that, and they're bringing an action for equitable breach of confidence. But in this case, the court is saying, no, you can actually use this as well for a breach of confidence involving two personal individuals around highly private sexual relationships. What the court said is if the information is sufficiently confidential in nature and context, then the confidant, the person who receives the confidential information, must not make any unauthorised use of that to the detriment of the person who communicated it. And detriment has been interpreted quite broadly and essentially includes embarrassment, loss of privacy, and it would also include physical harm caused to the person, for example, mental injury and loss. With a claim along this nature, the individual who misuses the confidential information can be held then accountable. Injunctions can be ordered by a court to restrain any further breach of it, and damages can also be awarded for any breach. And the general rule around awarding damages is that the restitution should then place the individual who makes the complaint in the position that they would have been in or would have enjoyed had the breach of confidence simply not occurred. So this is really a very important case around sexting and how people who engage in sexting, particularly in the context of a broken relationship and doing it to harm the person once the relationship has broken down, can be held accountable for that. Then the other cause of action that a person can have is in defamation. Defamation is essentially when something is published that is untrue and would cause an ordinary or reasonable member of society to think less of them. So a statement about a person's sexuality may be defamatory. It really depends on the nature of the content as to whether it's defamatory or not, but that's essentially another cause of action that an individual might bring. What's important to note here is that defamation is now so easy to do and to publish broadly with the move to social media and the digital age. Something can, whereas publication can be quite limited in the past, now publication can be very, very broad with simply a click of a button, and the ramifications can be very significant for the person who alleges defamation. Additionally as well, if you have your own notice boards within your school and there's things that are published on those notice boards, including electronic notice boards, you are accountable as the publisher of that to ensure that any defamatory material is removed as soon as possible. So there's an obligation on you to keep monitoring your own web pages, apps, Facebook pages and the like, to make sure that anything that might be defamatory is immediately removed. So what about duty of care implications for the school involved? Because this is when the implications actually come home to the school and the teachers. I think you'd all appreciate that within every teacher-student relationship, there is a non-delegable duty of care. It just simply exists by nature of the relationship, and it's non-delegable. That basically means you can't delegate it to someone else. You're ultimately responsible as the teacher or the school in respect of the duty of care owed to the student. And the duty of care is essentially to take reasonable care to prevent reasonably foreseeable injury to a student. The old High Court decision of Geyer and Downs talks about what that looks like. Children stand in need of care and supervision given their age when they're attending school, and it's the teacher's obligation to provide that to them. There's nothing unusual in that What's the duty? Well, the duty is essentially to do what any ordinary, reasonable school teacher would do. And it's not to do what the very best school teacher would do. Likewise, it's not to do what the very worst school teacher would do. It's just to do what an ordinary and reasonable school teacher would do. So that middle of the road type duty. Importantly, though, it's not to do what a usual member of the community might do. There's an expectation that you will act in accordance with what a ordinary, reasonable school teacher would do. So there's that higher expectation given the professional relationship that you have with the student. It's also not a duty to protect against all harm. The question is, well, was it reasonably foreseeable? That is, was it not far-fetched or fanciful? And what precautions could you have taken as a school or as a teacher to prevent the injury? So in the context of sexting, for example, it's happening outside of the school context, which you're not really aware of. Well, it's difficult to see how a school could be held responsible for that, particularly if it had appropriate policies and procedures in place that it communicated to students about how they should or should not conduct themselves. But what is important to note is that teachers may be then required to actually intervene to protect those pupils under their control or supervision. So it's not this absolute duty to protect against everything, but it comes into play of at what point should a teacher actually intervene to protect. And there's a case that comes out of the ACT that I think provides really good guidance in this regard. ACT Schools Authority and El Sheikh, 2000 Federal Court decision, which involved a 15-year-old student who was injured in a play fight at a school. And so this fight had been occurring between two students. There was a bit of a kick by one student towards the other student where he managed to strike him in a particularly sensitive area, caused actually quite a bit of injury to the other student, and the student brought a claim against the school. Justice Wilcox said at the time, well, rough horseplay symbolises the play activities of teenagers, especially younger males. It would require an army of supervisors to prevent any incident that might give rise to a physical injury. An injury might be sustained from something as quick, simple and common as one pupil pushing or tripping up another. It's not uncommon for boys to aim kicks or blows at their fellows, he said, without meaning to cause substantial pain or any injury. Unless an educational authority was prepared to impose a degree of regimentation that would be likely to provoke adverse community reaction, it would be impossible to prevent such incidents occurring. Now, bear in mind, this was a judgment that was from 19 years ago. Would it still be quite as favourable for a school today in that respect? I'm not so sure. There was probably a bit of an old school mentality there with that judge. But I think what he says here in this next line is really key for a school, and it still remains the case. An educational authority can and should prevent rough horseplay incidents going on for a significant time or escalating into a level of violence that's likely, under normal circumstances, to constitute a danger of life or limb. But it seems to me that's all it can do. So really what the school needs to be saying, particularly in the context of sexting and bullying, once you become aware of it, you've got to do something to respond to it. That's when the duty really quite clearly comes into play for you. So there's an expectation that a school would take some form of action in respect of sexting or bullying that's disclosed to it. And when you look at this next case of Oyston and St Patrick's College, 2013 Court of Appeal in New South Wales decision, we can see that coming into play more clearly. This involved bullying of the student, Mr Oyston, over an extended period of time. The bullying was reported to staff, but action taken was insufficient. Now, there was a bullying policy in place, but it wasn't properly implemented or followed, and there was simply insufficient action taken against the protagonists. So in that case, the court was satisfied that there was causation proved. Justice Toby has said, the application of common sense leads, in my view, to the conclusion that it's more probable than not, but for the failure of the college to actively implement the policy, the psychological injury of the appellant would not have occurred, or at least would have been minimised. So again, the policy wasn't complied with. Things were raised with the school, and insufficient action was taken. So it's not that different to what the court was saying in that ACT matter. What about if it's out of hours conduct? Does that result in liability? Well, I think the landscape's shifting here as well. I think that bullying policies require schools to take action when the bullying is reported, if it's involving students of the school, even if the bullying is occurring outside of school. And a failure to follow your policy may equal a breach of duty as what an ordinary, reasonable school teacher would do. Having said that, there would still be an issue to decide about whether the breach of duty at that particular time actually caused the harm. So if the harm was caused by sexting that occurred or distribution that occurred outside of hours, then you'd say, well, how could what the college did subsequent to that have stopped that harm necessarily occurring if the harm has already been caused to the students? So there's still some legal issues that will come into play there. But irrespective, really the expectation, I think, of schools is that once something is brought to your attention, even if it relates to things outside of school hours, that you really need to do something about it and respond to it in some way. So let's then move to, well, what are your reporting obligations around sexting? Look, as the law currently stands in Queensland, there's no general obligation on citizens to report criminal activity, but there is legislative obligations on certain individuals to report, depending upon the individual and the role they have in community, in the community. So for schools in Queensland, there's mandatory reporting for all school employees under the Education General Provisions Act, where it involves actual or likely sexual abuse against a student under the age of 18. They must report that to the principal and then report it on to a police officer. So sexual abuse is sexual behaviour where one person bribes, coerces, exploits, threatens or is violent towards the other person, or one person has less power than the other person, or there is a significant disparity in intellectual capacity or maturity. And you might find that sexting fits into any one of those three categories. It may be that the sexting is actually so serious that it involves some form of bribery, coercion, exploitation, threats or violence. That's going to depend upon the circumstances. It may also be that there is a significant disparity in power between the two individuals, between the two students. Or it might be that there is a significant disparity in maturity or intellectual capacity between the two students, depending upon their ages, for example. What is a reasonable suspicion? Well, essentially, in the area of sexting, I don't think you'd have too many problems in being reasonably satisfied to this degree, because you'll actually have clear evidence, being the sexting texts and the like, that it's actually occurred. But essentially, it's facts which, taken on an objective basis, lead to an attribution of sexual abuse. It doesn't have to be as high as belief. You don't need to believe that it's occurred. There has to be something more than a mere possibility. And it needs to be reasonable as well, but it doesn't have to be essentially well-founded or factually correct. So really, this legislation is slanted towards making reports, and it's seeking to have the reports made so that the police can deal with it. In conjunction with this, obviously, there's also reporting under the Child Protection Act here in Queensland, which also applies to school teachers. But that's where you're talking about a student who does not have a parent able and willing to protect the child, or to act to protect the child. That might be a little less common in this area. It may apply, but it may not apply depending upon the circumstances. So it seems to me that you're more likely going to find that you're reporting under the General Provisions Act than the Child Protection Act. But you might find that you've got a reporting obligation under both acts. Here in Queensland, we've just issued a bill around the proposed failure to report offence as well. That's going to apply to all institutions that provide services, care and supervision of children, so schools, but also churches and the like. And this legislation is primarily aimed at doing away with this concept of confessional privilege and saying that, no, it's far more important that these things are being reported to the police. So it's going to apply to all adults that are associated with the institution. So that will include employees, managers, directors, and volunteers. So be aware of that. It's quite a broader application, and it will require disclosure where there's any sexual abuse of a child by an adult who is also associated with the institution or is a relevant carer. And so an adult who's associated with the institution, again, is any employee, manager, director and volunteer. Maybe you might find that some of your students are also in some capacity also volunteers, and that's going to depend upon the circumstances. So you might find that you've also got a reporting obligation under this proposed legislation. A child is any person who's under the age of 16 at the time of the abuse, or otherwise where the abuse is by a person in a position of authority, in which case the age limitation goes up to 18. So if we're talking about a teacher, for example, then that's going to require reporting under this proposed failure to report offence. The reason I'm raising this proposed offence here as well is because the consequences of not reporting are more significant for the individual concerned than the Education General Provisions Act. We're talking about 3 years imprisonment penalty. We're talking about what's going to be a breach of the criminal code as opposed to the Education General Provisions Act. So this is a more significant offence than the Education General Provisions Act. Having said that, there's no obligation to report under this particular provision if the report has already been done under another provision. So if you've reported under the Education General Provisions Act, you won't need to report under the proposed failure to report Act. I've just seen a question that's come in on this. I might just have a quick look at this question before I move on and answer that. The question is, based on what you've said, must a school report to the police if significant sexting has taken place, even if you're working with both parents and students in a positive, supportive way? Well, look, yes, if it comes within the Education General Provisions Act. If what has occurred fits within the sexual abuse provisions and involves a student under the age of 18 and it involves one of those three subcategories, then really that obligation to report applies. It's not something that you get to choose to not report or to report. If the legislation applies, you really should report it and leave it with the police to decide what to do with that. And there's protections in place for you as teachers and as schools when you make those reports. Legislation is clear. You make a report, you're not going to be liable under any breach of privacy, breach of confidence provisions, because the expectation is that you will report in order to properly fulfil the obligations in respect of the student concerned. Otherwise, if a mandatory reporting obligation doesn't apply, then you're talking about reporting depending upon all the relevant circumstances. And there's a range of circumstances that might come into play, such as what's the extent of what occurred, what is the attitude of the victim and the victim's parents and how they might want to proceed, how is the perpetrator responding, for example. But always, in my advice, is always to take advice before you decide not to report to police and to exercise caution, because at the end of the day, you will be held accountable for not making that decision to report, not someone else. The obligations to report are on you personally. Moving along then, just wanted to look at the Office of the Children's E-Safety Commissioner as one way in which you can also seek to have online abusive content removed. That's a Commonwealth statutory body which has been established to both provide education for students and schools around this whole area, as well as to assist in actually removing offensive material. And so they've got actual relationships with the various service providers like Facebook, where they can get things taken down very quickly. So this is a very important entity to be aware of if you are looking to have material removed. So then how do schools respond to all of this in closing? Well, first of all, whenever you're dealing with any of this, the first step of most important is to consider the needs of the abused student. Make sure that they're receiving some form of support and counselling, giving them referrals to appropriate support networks, including the Office of E-Safety, for example, to assist them, make sure that their care is being looked after. That's your first most urgent priority. Secondly, then, consider what are your reporting obligations and how you're going to fulfil those reporting obligations, and obviously make sure that you keep a note of what reporting you do. When you're then undertaking any of your own internal investigations, it's obviously a key that you don't prejudice what the police are doing. So take their advice first about what they're doing. They will tell you if they want you to hold off until they've done something or they've spoken to the relevant people. So always take their advice. Secondly, make sure you don't keep any images yourself of child exploitation material, child pornographic material. You don't have a lawful basis to keep that. So if you've been given that, give that straight to the police. Don't hold on to that yourself. Make sure you then separate your role from the role of law enforcement. It's a role of law enforcement to investigate criminal behaviour. That's not your role. Your role is around management of the school, educating the school, the students, and fulfilling your duty of care. So make sure that you keep those quite separate. What you're focused on is your school management role, not what's happening within the criminal context. Make sure you keep accurate notes of what's occurred, bearing in mind that you may be a witness. But those notes have to be simply unbiased notes of what has occurred, what you've been told, what you've seen. Whatever you do, don't keep opinions within your notes, bearing in mind that those notes might become evidence in any subsequent court proceedings. And be as fair as unbiased as you can when you're collecting evidence and supporting various students. You don't want to be casting judgment necessarily. Your role again is one around school management and duty of care. Then make sure you deal with the offender. Apply your policies around discipline and bullying in a consistent way, in a fair way, but don't be afraid of applying those policies, and don't let it be seen down the track that you haven't properly applied your policies. You may, as part of applying those policies, be able to exert influence over the offender and parents to have online content removed. Don't be afraid of using that influence as well, if necessary. What about if what's occurred is in the media? How do you respond to that? Well, you're going to need to be taking some advice from your media representatives. So you will have some form of PR consultant, hopefully, that you can draw upon. I always say to my clients, don't get lawyers to draft your media statements. They just won't be great statements if lawyers draft them. They'll be too focused on legal rights and protecting the school's interests and the like. Far better to have your media statements drafted by your public relations consultants and then have those reviewed by your lawyer. So we can provide comment on what they say and make changes as necessary from a legal perspective, but I always find that these statements are much better if they're written by your PR consultants. They just have a far better way of communicating than lawyers will have. Never ever identify a victim publicly, either expressly or by implication, other than to obviously law enforcement bodies. It's just a clear thing that you just never do. The identity of the victim should never be disclosed. Also, never identify a child offender publicly. That's another thing that you just should never do. And in all of the circumstances, don't be afraid of taking early advice from a team when it's a sufficiently serious instance. So take advice from public relations experts, legal experts, counselling experts and the like, so you know how you're responding to it. So that's the end of my presentation, but I'm happy to take any further questions people might have. Just while people might be putting on questions, I might just make a couple of final comments. Our contact details will be on the slide as well. So if you need to make contact with us directly, you can, and the slides will be made available to you. This is actually our last webinar for 2019, but we will be in the area of school law. We'll email out our school law listings with topics for next year. If you do have any other questions, though, don't be afraid to make contact with us or our client engagement team. We also have a particular offering that we give to our school clients or potential school clients, which is a free 45-minute consultation. So if you would like the benefit of that, please make contact with us. If you're in the Brisbane area, we can come to you. Otherwise, we can do it remotely as well if you're regional or interstate. This webinar is also being recorded, and so it will be available if you wanted to listen to it or to have other people within your school listen to it as well. I'll just make sure there's no other questions. Thanks for your kind comments in relation to it, to the presentation. I do hope it's been of assistance. There aren't any other questions, so that's great. We'll finish it up now, and I hope you have a great rest of your day. Thanks for coming.